Good morning, members. This is a meeting of the Subcommittee of Rules of the High Court Amendment Rules 2017. This is the first meeting. We have formed a quorum, so let's get started. There are only 3 of us. We need nominations. I nominate you. I second it. Well, at about a 15:15, I would have to be otherwise engaged, and I believe by a 15:15 I will not be able to finish this. But I have other engagements. So nomination from Mr. Alvin Young seconds the nomination made by Mr. Holton Chow. Okay. So I would declare myself elected chairman. Do we need a deputy chairman? No. Please invite the officials to join us.
多20%，多1/3啊呢度。提個會，
有杯暖水幾好啊！
辛苦晒。我等人哋坐低先，我唔需要。我咪水睇木到。
好，第一次會議我介紹一下呢。This is the first meeting, so maybe I should introduce the team from the administration. We have Ms. Wendy Zhang, Assistant Judiciary Administrator, Ms. Winky Lam, Senior Administrative Officer from the DOJ, Mr. Newton Chan, Senior Assistant Law Officer, Ms. Elaine Ng, Senior Government Counsel, and Mr. Alex Lai, Government Counsel. So I'll give the floor to the administration to introduce the amendment rules. Well, the rules of the High Court Amendment Rules 2017 contained a basket of amendments, so I would need more time to go over them. On the whole, we introduced the amendment rules to improve the rules of the High Court, and the details can be found in the Legislative Council brief. We cover 3 main areas. A, in respect of disciplinary proceedings of solicitors, when there's appeal made to the Court of Appeal, there is the automatic anonymity requirement for the appellant solicitor. But we have make reference to the arrangement for other professionals such as accountants and barristers, and in order to uphold the principle of open justice, we propose to remove this requirement of anonymity, and we will be in line with other jurisdictions such as the UK. And we have consulted the Law Society and the PVC Commissioner, and they have all given their support. Second, to improve the court practice and procedure for civil appeals to CA. Under this, we have 3 amendments. First, to enhance case management. The parties to the proceedings can make amendments to the notice with leave from the court. If not, they can only amend the relevant court document 3 weeks before the hearing. Whether we're talking about the notice or judiciary to the judiciary, there's they can move an amendment if it's made more than 3 weeks before the hearing. There's no part to be played by the court, and we think that this is not ideal. So in order to make a better arrangement, we would like to tighten the requirements, and that is without leave from the court. The time limit would count on the will come to an end at the date of fixing the hearing. Because if there are major amendments made to the notice, the time taken for the appeal may be affected, and it will affect the pre-hearing preparation of the parties. Therefore, we would require leave from the court, and also to allow the court to take into account the latest developments of the case. Secondly, we are going to introduce the arrangement for the list fixing the date. We hope that there will be a clearer framework in the rules. Under one of the rules, that is, when the registrar is of the view that the court is fully prepared and the case should go before the court, then at hearing date of the appeal will be fixed. This is to make the proceedings more efficient. And the third one is for the court of first instance to consider a time extension applications. At present, only the Court of Appeal can approve of time extensions for appeals, but not of the CFI. This is rather an anomaly. If we look at the Competition Commission or the District Court, they both enjoy this power of extension, but only CFI is not given this power. In order to allow the three different tribunals, that is CFI, Competition Tribunal, and District Court, enjoy the same power to approve extension, we would like to propose that CFI can also approve time extension applications. The third area of the amendments under this head is to remove every expression which is bracket HK from the rules of the High Court. The rules were enacted in 1988, so based on the UK, the High Court rules. The civil procedure rules of the UK. We copy the numbering from the civil procedure rules, but there are certain rules which are unique to Hong Kong. So for those rules related to Hong Kong only, we would have a bracket HK. Bracket HK inserted to identify them. In 1999, there was a review in the UK, and their CPR, Civil Procedure Rules, have been replaced. The RSC has been replaced by the CPR. Although we were, and in 2009, we also have a civil justice reform. We have incorporated some of the amendments in the new civil procedure rules, but there are other things that we are already not in line. Since 1999, those rules unique to Hong Kong do not contain the word bracket HK. And any amendment since 2009, we no longer insert the term bracket Hong Kong in the rules. So for some rules, you see this term bracket Hong Kong. For some other, they're not there. It's not there. So it's not very convenient to the reader. So when you see a rule without the term bracket Hong Kong, there are many possibilities. It can be a copy version of the equivalent UK rules, or it can be a new amendment. Under Chapter 1, the numbering has no legal effect. Therefore, we would like to remove all the expression bracket Hong Kong in the rules of the High Court. Apart from the 3 proposed amendments, there are other minor amendments to the rules. Let me now turn to the consultation. Like other amendments proposed by the judiciary, we have consulted various stakeholders, including the Hong Kong Bar Association, the Law Society, and the Privacy Commissioner for Personal Data. They are all supportive of the relevant amendments. In February and May, we issued 2 information papers to the AJLS panel. Members make no comment on that. That's the introduction to the amendments. We're happy to take questions from members. Okay.
Let's see if members have any questions to ask. Yes? Thank you. And I also thank the DOJ for the detailed explanation. I have some questions to ask first. In relation to the name of a solicitor in the title, there is a change. In the paper, there are some UK cases stating that there should not be any special treatment towards solicitors only. The practice of non-disclosure is a matter of legacy. Perhaps a few years ago, the disciplinary hearing was not in an open hearing, and now it's changed. Disciplinary hearings are open just for other professionals, say for example doctors and dentists. Names will be disclosed. So I'd like to know, in Hong Kong, is it the same case? That is, for other professions, when it comes to disciplinary hearings, names are disclosed in the hearing by the relevant panel or board. Thank you. In Note 3, you see that we have looked into, say, the Professional Accountants Ordinance and the Medical Registration Ordinance. The conclusion we have drawn is that the name of, say, the accountant or the doctor, when the case reach the court, will be disclosed. So our proposal is to align the practice to the same arrangements as other professions. Anything else, Mr. Chow? I have a supplementary question. In the case of solicitors, there is a non-disclosure. That was the practice, and it existed long before the Professional Accountants Ordinance and the Medical Registration Ordinance. Is that right? Or is it the case that when the practice of non-disclosure was in place, names of accountants and doctors were already disclosed in hearings? We have not looked at the timing. I think that the legislation in Hong Kong mirrors that of the UK. And in paragraph 11, you see a recent interpretation of the UK because they have adopted a similar exercise to remove this practice. In the past, there was non-disclosure, but in recent years, in a number of places, they have adopted a similar exercise to remove the non-disclosure requirement. There is detailed explanation in the UK case that, the practice, the approach for solicitors has a very long history. However, is a remnant from earlier times, and now times have changed because it is no longer in the position that disciplinary proceedings are in private. But we have not looked into why there are no similar requirements for accountants and doctors. Well, we follow the UK practice, and it's a remnant from the past. And it is not in line with the situation nowadays. Mr. Zhe, let me declare that I was subject to a long-drawn process related to this. I don't know why, even when it comes to appeals, the party is only a solicitor without any names. And in footnote 2 on page 4, well, the practice for barristers is different. Well, I think in Chinese, you only add the word that means big, a big lawyer for barristers. I think that needs to be changed. Proceedings against barristers may be in private. However, the barrister involved can make a request to open to have the hearing open to the public. However, for 13 other professions, say for example accountants and doctors, there is a requirement that hearings will have to be open. However, when it comes to barristers, it's subject to a request. You might as well deal with this, because this is an outdated approach that is not in line with other professions. Thank you. I comes from the judiciary. So the proposed amendment is related to court procedures, and what you've mentioned is related to the Department of Justice, which is the regulator of barristers and solicitors. And I think that will be an amendment to the principal legislation. I'll be happy to reflect your view to the DOJ for them to consider whether to have any amendments. It is not appropriate for the judiciary to make a decision for them. That may be the case. If you let it piggyback in this exercise, it will be really easy to do. Well, because it's something to do with the legal practitioners' ordinance anyway. We can't make the decision on behalf of the DOJ because it should be a separate amendment exercise. But I will forward your view to the DOJ. Yes. I once thought about a private member's bill to introduce this amendment. I don't want barristers to be a species of their own. There needs to be more transparency, and I do think that it has to be amended as well. I'd like to ask, the procedures related to barristers is not related to the rules of the High Court, is that right? Footnote 2. It says the Legal Practitioners Ordinance, Section 35, capital B bracket 2. The open hearing in camera, I know is something to do with the LPO, the Legal Practitioners Ordinance. What about those tribunal proceedings, rules, and others? They are not related to the rules of the High Court? I'll defer to Mr. Chan. Our understanding is that it won't, because we're talking about Order 102 that focuses on Rule 12(1). It's in relation to solicitors in disciplinary proceedings. For barristers, if they lodge an appeal at the end of a disciplinary proceeding, they will lodge the appeal to the Court of Appeal, and in the notice of appeal, the name of the barrister will be stated. So when it reaches the court, everything will be disclosed. Yes, that's for the case of barrister. So that is, barrister's name will be disclosed at the stage before ours. We will just say re solicitor, and then in their case they will say re and the name of the person. Any other questions? I have something to ask. I'd like to know, the Court of First Instance does not have the power for extension, does not give the power of extension. How come? Because District Court has this power. Is it the case that they have been given this power in the past decade or so, or it's been a very long time when the District Court has this power, whereas the CFI doesn't? The District Court Ordinance is more, is newer, and in year 2000 there was an amendment. Yes, that may be a matter of time. However, the Competition Tribunal Ordinance is quite new. I was involved in drafting that. It was when we were drafting the Competition Tribunal Ordinance that we identified this peculiar point. That's why we want to propose this amendment, because the CFI will have to first go to the first tier of court for application for leave of appeal before it goes to the Court of Appeal. That is the same mechanism for different levels of court. However, now we find that the leave for appeal is dealt with by the Court of Appeal instead of the CFI. This unnecessarily adds to the workload of the CA. And, well, in general, an appellant will have two chances to apply for leave for appeal, once to the CA and then the CFI. And Court of Appeal judges said that the first tier of court judges would like to know about new points of law. So the view of the court in the first tier is very important, because it will enable the Court of Appeal to decide whether to grant leave. However, because of this hiccup, the Court of Appeal judges don't get to know about the comments of judges of the first level. And we identified this peculiar point. That's why we proposed this amendment. Well, you haven't answered me about history. The 2 points you have made is not on the LegCo brief. And I think these 2 points are really convincing. It is in it, yes, but not in those words. And I think in our report we have to put these in. You can't just say that it's peculiar. It has to be supported by justification. Mr. Zhe? Well, yes, it's written there, and I want you to look at paragraph 25. I do support this flexibility, but I'd like to know the time extension. Do you have any requirements in mind? Say footnote 7, Rule 50. I don't have the time to check it. Is Rule 50 of the Competition Tribunal rules and the rules of the District Court. Well, does it specify the time to be extended, or is open-ended? Mr. To's question about a second attempt to seek grant approval of leave to appeal it at the Court of Appeal. The CFI's power to extend should be related to the Court of Appeal. Otherwise, one may apply for an extension of time to the CFI while at the same time apply for leave to appeal from the Court of Appeal. That will be rather confusing. So if you make an application with the CFI, and if you don't make an application to the Court of Appeal, then you can't apply to the CFI for extension. It's very complicated. It doesn't matter if you don't understand. Well, let me try to answer you. We have taken reference of the rules of the District Court as well as the Competition Tribunal rules. I have the sections. I can read them out to you. They are very simple. It says that the judge has been given maximum discretion. When time has expired, sometimes action will be taken before an expiry. Some others will wait till the time has expired. However, they can still make an application under the Competition Tribunal rules and the rules of the District Court to make the application.
So you mean both have the power, but you say it would be better for the Court of First Instance to consider this first, but there's no rule requiring that the first application must be made to the CFI. Well, the appellant will be given two choices, either to go to the CFI to apply for extension out of time, or he can go to the Court of Appeal to seek an extension at the same time. Are you going to ban any concurrent applications? I think it would be best if we say that they should go to A before going to B. Under the rules of High Court, there's relevant provisions to prevent this. It's Order 59, Rule 2B, Paragraph 3. Paragraph 2, rather, as far as practicable, the application must be made. The judge or master who make the original decision or make original order. So you should go to the judge or court that grants the order in the first place. So there's no question of waiting until it's out of time, and then I go to the court to seek application out of time, and at the same time going submit another application in parallel to the Court of Appeal. There are precedent cases under the of the Court of Appeal that unless it's an exceptional case, otherwise application for time extension must be submitted to the Court of First Instance or the original court. You cannot say that I'm out of time, it's over 14 days, and I will go to the Court of Appeal. Well, but without the amendment, they would have to go to the Court of Appeal because the CFI is not empowered to do this. So with the amendment, the appellant will have to go to the call of first instance first. All right? That's, I believe the expression bracket Hong Kong is not controversial. All right. Can we go over the clauses, Secretary and Legal Advisor? The amendments related to the term, the expression bracket Hong Kong is not going to be a problem. Just tell us. What about the other clauses? You want to say something? Okay. Legal Advisor? A small point for the law draftsman is 13(1)(a) in the amendment rules. Order 1, Rule 7(a), and the repeal of the heading and the text with the expression of HK, bracket HK.
第17頁。
中文啊嘛。
Page 17 in the Chinese version. The expression bracket Hong Kong appears both in the heading and in the text. Rule 7(a) will see we have the term H bracket HK removed, and it's also in the heading. So can you confirm that both expressions there will be repealed? Yes, I've talked to the legal advisor before the meeting. It's just a way to express the amendment. So you are correct. We will be repealing the expression bracket Hong Kong in the heading and the text. If you look at clause 13, sometimes we specify heading because the term bracket HK is only found in the heading, so we will specify heading. But in the in Rule 7(a), both the heading and the text, we would repeal every expression bracket Hong Kong, both in the heading and in the text. Is that okay? It's just a way of expressing the amendment. The effect of doing this is to repeal all expressions bracket HK. Well, I do have some opinion, but I would keep it to myself. Let's go over this quickly, just to be safe. I won't pay more attention to those amendments related to the removal of the expression bracket HK. Let's use the Chinese version 0001 2B. We'll make reference to the rules of the district court and the rules of the competition tribunal. We would allow the court of first instance to consider an application for leave to extend the time limit. 002. There is a new 6A which will take the place of this particular provision, 0003. And we would like to take this opportunity to provide clear legal favor for fixing of date for hearing appeal. And the registrar should first of all, make sure that the parties are ready for a determination to be made by the court. So this is to enable the efficient utilization of court resources. Okay. 0004. It's going to change the time of notice. As I've said, 3 weeks before the hearing, the amendments can be made to the notice without the court's leave. So we are now changing this. Once the hearing date is fixed, no amendment can be made without leave from the court. So in the past, you can amend the notice 3 weeks before the date. And now, once a date is fixed, and it's 5 or 6 weeks before the hearing date, no amendment can be made. What should be done? Well, you should seek leave. Let's say, if you delete every controversial issue, and then perhaps the court may say that instead of a few days of hearing, the time would be much longer. So the judge may have to consider why the amendments are proposed at such a late stage, and are there consequential changes that would be needed. For example, the other party may need more time to prepare for the hearing. So the court would grant leave after taking into account such factors. In the past, let's say just 3 weeks before the date, they can just go ahead and amend the notice. And let's say there are 4 weeks because the hearing date has been fixed, and now a party applies for leave. And if this is not allowed, then the proposed amendments can be handled on the day of hearing. If an application has been made, which may affect how the hearing is conducted, then the hearing date may be deferred. Or if it's not fair, the application is denied. But if it cannot be done in practice, then the amendments will have to be considered on the date the hearing starts. So can you tell us what's the average notice, or how advanced the application should be made on average? Well, there can be different scenarios. Some parties would like to amend the notice of appeal or respondent's notice. So that the application can be heard and considered on the date of the appeal. And some would like the applicants to be considered before the date of the appeal. The court would pay regard to different factors, whether the application would cause any substantive implications to the hearing, and would it also be unfair to parties to the appeal, and whether the application would lead to other applications. If I amend the I want to amend the notice of appeal, then the respondent may have to consequentially amend the respondent's notice. So the court will have to look at the entire case and make a ruling. We cannot generalize. But that can be a problem. Why was Rule 7 worded in such a way? There's some wisdom in that. Under Rule 7.1a, well, you can seek the leave of the court for amendment. If you want to amend the notice of appeal, you can seek leave of the court. And if you can do this 3 weeks before the date fixed for the hearing, because it's considered that 3 weeks will be sufficient. Well, the judge may award cause because you make late amendments. The amendments were made, say, 4 weeks before the hearing date. And now under this new amendment, there's another mechanism. You should apply well in advance.
And in your application, you will have to say, with the additional procedure, well, under the old system, that would be 3 weeks, and you did not have to do anything. This may be a minor amendment, but you will have to make an application 3 weeks prior. This will add to the workload of the court. Do you understand what I'm trying to say? There are a lot of cases, examples of the Court of Appeal that shows that there is abuse. Directions have been given by judges of the Court of Appeal. So we have changed something in the practice direction to prevent parties from making the application when they're not prepared or doing it last minute. So we will have to make sure that everything has to be in order, and they will have to tell the registrar that there won't be any further changes and everything is ready for the court, for the case to be heard before it's fixed. The old approach is not in line with on a practical reason, because there is a huge workload and there is a chance of abuse because they would like to drag the proceedings. Well, I have to believe what you say before we agree with the changes. So in practice, if we keep 7, it means, well, you have found that there are a lot of irregularities. Because of major changes, 3 weeks later, the case cannot be heard. The date has to be vacated and the time's wasted because you can't simply make arrangements for another case to be heard. You will have to tell us that.
Okay. 講有介紹呢個理據嘅嚇。
Well, you are practically coaching them, but this will be clearer. Yes. Just now you mentioned about masters, but the leave has to be sought from the Court of Appeal, either a single judge or a full court. You want to reduce the workload or a chance of abuse, but you have ignored the implication on costs. Because if one wants to change the notice of appeal or statements. If it's a genuine case, that means there will be another additional interlocutory procedure. Is there some? Can you meet us halfway? Not as short as 3 weeks, but don't disallow them from making any amendments. That there is a chance for them to make changes without having to apply to the court for a full hearing. Yes, you give them 3 weeks, they may abuse it. But what about striking a balance? Say 3 months before. Say if you say 5 months. And, well, you are still allowed to make changes 3 months prior. We would like to change it because we would like cases to be ready before a date is fixed. It's not a time restriction. There is an additional registrar in the High Court to deal with civil proceedings. The registrar requires parties to give forewarning about any possible changes and to furnish documents. A date will be fixed when there will be no more changes. It's more in line with the operation nowadays. Well, but the registrar can't do it. It has to be a judge of the High Court. It's something that the registrar can't do. You need to give more flexibility. Perhaps I will defer to Mr. Jan. Thank you. The latest practice direction, a lot of the applications can be dealt with on paper without a hearing. This will address the issues of additional costs. So how many percentage can this be done? According to the practice manual, most of them can be done by way of application by paper. It's 4.1 of the practice manual.
對唔住啊，我哋冇 hot pen 冇喺度睇到個 details。嗰個係 applies to even a judge.
So it applies to a judge, not just masters. No, not masters, because when it comes to appeal proceedings, it is dealt with by the Court of Appeal. Say, for example, application for amendments after a date is fixed. The court can still deal with it on paper, by way of submission of papers without a hearing. Of course, the other party may object to it and request a hearing. But the court has the discretion to deal with it without a hearing. So this kind of wholesale amendment even with it written in practice direction, but how is it done by the court, with hearing or not? Well, the other party can oppose to it and ask for a hearing. If the court gives directions for it to be dealt with by paper submission and the other side oppose to that, say for example because there are too many changes, I ask for a hearing, then the court will have the discretion to decide. How come that there was this 3-week period? Is it because of historical reason? Well, Ms. Zhang said that it is outdated. I understand. But there must be some reason. In the past, appellants were allowed to make amendments taking into account of changes of the latest situation to better serve justice. But now, 3 weeks may be too short with technological advancement. So can you strike a balance? Instead of adopting an across-the-board approach, whether it is a paper here, whether it's handled by paper or hearings, the situation might have changed completely. It would be better for you not to put in so many obstacles. And I think 3 weeks is already a balance. But there is a trend that the 3 weeks may be abused. But what about 3 weeks before? Will it be a better balance? I'll first speak. Mr. Chen may supplement. We have looked into many different options. We noticed that cases are different, the complexity may be different, number of parties may be different, and if we put an absolute time frame stating that, well, before this time you don't need leave from the court, this will not cater to the diversity of cases. We have looked into different scenarios and options. This will be a balance. I understand members' concern. If a simple change may involve the court, it may not be appropriate. When it comes to minor amendments, before a date is fixed, that will have to be dealt with under practice direction. So 99% of the time, there won't be any sudden change. However, when a date was fixed, maybe it was 6 months ago, and perhaps if you're not happy with all the information, you may want to change, make small changes, and it can be dealt with on paper. And I do think that that will be preferred because it will save costs. We will reflect your view to ask the court to take into account cost implications. Well, unless we carve this out, well, the case is that if everyone agrees, then it will be dealt with without a hearing. Otherwise, it may need a hearing. If you think there is serious abuse, even if you give 3 months, someone will abuse it by, say, submitting a brand new notice to a notice of appeal.
比較用心啦，即係我諗到最極端。你3個星期
Say, for example, the extreme case. Well, if you change everything 3 weeks before, you won't be able to get everything ready for the hearing 3 weeks later. Say, yes, you have submitted a completely different notice 3 months ago, 3 months prior. And you won't be able to drag it on to not use the date of hearing. The court may impose conditions to ensure that the case will be heard 3 months down the line, so that the party involved is not able to drag the case on. Well, if you give them 3 months, a chance of you missing the date fixed will be smaller than 3 weeks. And I think, well, you want to keep the flexibility. If you think 3 weeks is too short, we can change it. But if you take it completely away, then you have ignored reality. Well, now you practically say that once a date is fixed, nothing can be changed. Well, when is the date fixed, and what is the time interval between that and the hearing date? Well, let me explain to you why we don't think 3 weeks is too rigid. In March this year, we have formulated a practice direction. It includes a new arrangement to require parties, once a date is fixed, once it's set down, they have to submit a joint checklist before a date is fixed. This joint checklist has merits because they will have to tell us the estimated length of hearing, any special considerations, and appeal bundles are all ready.
There's no further change or other outstanding applications to make. But with this new arrangement implemented in the last few months, well, the registrar would consider the case, and the parties have a consensus. So what the members have said could happen, but in the light of the experience with the introduction of joint checklist in the past few months, whether we're talking about big or small changes or the disagreement, we have a new channel to handle this. So your concerns are not borne out by the past 3 months' experience. But 3 weeks may mean a very short time for one hearing, but not for another hearing. Some will involve major changes, some will involve just deleting a few words. Under the civil justice reform, one of the, well, of course, we were just dealing with CFI and DC. One of the things that we want to do is to strengthen case management. We have gained very valuable experience from the civil justice reform, and that is that the judge should manage the arrangement of the case. And we don't want parties to make use of existing rules to cause delay or to do something which is not in line with civil justice. And we want the court and the judge to be better equipped and better empowered to manage court cases. So this is in line with the spirit behind the civil service justice. And through the years of experience, we think this is the right way to go. I think we need more information to respond to Mr. Chair's question. I would now give the floor to Mr. Houghton Chow because he has got other questions. Is this related to another amendment? I think in paragraph 22, it said that it would provide a clearer framework for setting down cases. So the basic principle is that we set down the case for hearing when the parties are ready. In the past, we submit a unilateral checklist. Now it's a joint checklist. So at that stage, I'll ask both parties that we have all the ticks in the boxes, and you are ready. And then I would set down a hearing date for trial, for the appeal. would that mean that the setting down stage would happen later than what it is now? Because there may be a big time gap between the set down date and the hearing date. So maybe in the future, there will be a smaller time gap between the setting down the date and the hearing date. Let me provide some supplementary information here. If an appellant lodges an appeal, he will issue a notice of appeal for filing by the court, and the notice will be served on the respondents. That's this so-called set-down procedure. The hearing has not really started, and they want to apply for the date to be fixed. After the notice is filed on record under the new practice direction, all the interlocutory procedure will have to be completed first, and then the registrar is satisfied that everything has been done before a hearing date of the appeal is fixed. When the parties apply for a hearing date to be fixed, a checklist is to be furnished. In that checklist, both parties must confirm that all the interlocutory proceedings have been completed before the registrar would really fix the hearing date. I think Mr. Chow is saying that with this amendment rule, it's not easy to fix a date. When the fixed date, the date will be fixed, is going to happen later than what it is now. Yes, on page 0003, we have a new Rule 6A. That is, we'll wait until all the parties are ready before we fix the date. So it's going to happen later than what it is now. So simply put, in the future, you will be asked very clearly whether you are ready or not. And don't you ever think about moving amendments or making amendments 3 weeks before the hearing date. So no amendment before the hearing without leave. And you can apply for leave. And since the hearing date is fixed after such a very stringent requirement, it's more difficult to fix a hearing date now than the court is less willing to allow amendments to be made. And so you lose. You will not be forced to vacate so many hearing days because someone happens to amend the notice 4 weeks before the hearing date. So because of the smaller time gap, it will not be as easy as in the past. Can you tell us the average waiting time before the appeal is really heard? Are you talking about recent development? There was a 2009 version in the civil justice reform. You cover the CFI and the DC. Is it that you are seeing that the Court of Appeal is facing similar problems, and you want to cover the Court of Appeal? I'll check if I've got the statistics. But when I talk to the judges, the actual time between fixing the hearing date and the actual date. That depends on the case. It can be heard in a few days if it's urgent. I will have to check. There are so many cases. I can provide the data. I'll see what I can do. Well, if the time gap is big, say it's a year, then we may have to consider whether we should be more tolerant about amendments. Well, under the civil justice reform, we look at the first tier of courts, that is CFI and DC. We have been implementing the measures under the civil justice reform in the past 8 years, and we are now applying the principles to different courts, such as the family court, and now we are trying to bring it to the Court of Appeal. It's just like a pilot or an experiment. If it's good to the CFI, we would like to apply it to the Court of Appeal. We may not be able to apply everything to all levels of court, but we believe that this is a good principle that should be extended to the CA. I think it's prudent to introduce amendments in phases. Yes, we should rely on experience so that suitable amendments can be applied to the Court of Appeal, and this is one of them. And we monitor the situation. So when Mr. Chow raised this question, I understand the logic, the interlinked relationship between different amendments. Would you like to ask further questions? Well, I'm not objecting to the amendment. I just want to seek the additional data so that I can pass it with ease of mind. Maybe today we can go through the rules, but to play safe, we still have time. I think we would resume our meeting some 10 days after the start of October. Let's do it by paper application. Well, good point. Page 6, 5, 0005. The words or after are added so that the CFI can consider the extension of time application. The same expression can be found in the DC rules of the DC and the rules of the competition tribunal. So it's either upon the expiry of the time limit or after that. .006 is a textual amendment under Rule 2(4). The order of the Chinese words will be reversed to mirror the same expression in English. 0008, another textual amendment, is a 14(a). The punctuation mark in the Chinese version will be, or the comma will be replaced by semicolon. All right. 0009. Disciplinary hearings of solicitors. Through this amendment, the anonymity rule will be repealed. What was the expression 如有的話 if any? Oh, I don't understand why in Chinese it's a 如有的話 instead of 如有 for if any. Are you talking about number 8? Number 8? It's a question of drafting. My Chinese is not good.
如有的話咧，一定唔係淨係喺我哋呢度有嘅。
知道。
Okay.
I would say that this term, if any, is not found only here. I think it's for the law draftsman. It's not just in the rules of the High Court. So perhaps you can reflect to the law draftsman that should the expression be couched like 如有 instead of 如有的話 for if any.
Say if applicable or if so, 如適用, 如有. Well, don't take it into account in this exercise. Consider it as a whole of all legislations. Legal advisor. Still, page 8. It's Order 102. And it says that the list of creditors entitled to object to such reduction, as is mentioned in Rule 7(4), as settled by the court under Section 227 of the Companies Ordinance, Cap 622. And it says here as settled. If I refer to 227(2), the CFI uses a different word, saying that the CFI has to draft a list. That's to the effect. Where Order 102 is under Companies Ordinance, it's outside the scope of the judiciary. Your observation will be forwarded to the relevant policy bureau. Sometimes it's not just a change in wordings. It may carry some substantive change that is outside our scope. I will forward your observation. Rules of the High Court are often changed by other policy bureaus, so it's for them to consider. Well, Cap 622 Companies Ordinance, Section 227 is something done under Section 227 mentioned in Rule 7(4). So is the part related to Section 227? Does it mean that there are many different parts in 227 that involves this power? Sorry, I have 227 here with me. It says, well, let me ask the legal advisor from this angle first. You think, is it the case that you think that is to be changed or what? I don't understand. It says Section 227, and it says that the court under this section prepare a list. If you refer to Section 227, the wording is a proposed list, 擬備, and here is the word 擬定. Well, actually, the word in both versions is settle. However, Chinese is different. One is 擬定, the other one is 擬備. So if you change this one to 擬備, there will be consistency. So is there another situation that doesn't refer to 擬備 under Section 227? So it's about the same thing? Perhaps I ask you to go back to think about it. If you could change a semicolon, if it's the corrigendum is a corrigendum, perhaps you could change it as well. Thank you. Order 102 is not under the scope of the judiciary. I understand. Well, whether it is the judiciary or not, that I understand. Well, please don't mind. You said, well, this is the High Court rule, so it's a semicolon to separate judiciary. And now Section 227, and this is not judiciary. I think it's too bureaucratic. Perhaps I didn't put it clearly. This is at the request of the Department of Justice to introduce these textual amendments. Then you ask the DOJ to coordinate. If they ask you to use the word 擬定, then you tell them whether you agree or not. Perhaps we will talk to the DOJ to find the best way to address members' views. To do it here or to do it in another exercise. Yes, just ask. You don't need. I don't want to hear that we are the judiciary. We will change a semicolon, but we won't change anything here. It's identified by us. But if we see it and not do anything about it, that is different from not seeing it. It's just like what Mr. Tse said. The word if any, 如有的話, then they may have to change many places. Well, just think about it. Consider it. Then it's page 9. Is the solicitor disciplinary proceedings the non-disclosure of name? Well, if members don't say anything, we'll just keep going. Page 10 is textual. Page 11. Well, page 10, there is no Chinese change. And page 10 involves the English version only. The word 條例 is added. So you won't see it in the Chinese version. And in the English version, you see the addition of the word 條例, ordinance. Page 11 is forms number 44, 42 and 44. And it's the typo. It's in the Chinese version. And it's changed to 今天, today. That's the same for page 12. Let's move on. Page 13. They are all about the reference Hong Kong. Legal advisor, do you confirm that all Hong Kong in bracket have been removed? Is that right? Then we don't have to go through them one by one. This is what I suggest. Give us a written reply on a number of points. Then I'll ask members if we need another meeting. Otherwise, that will be it. If there is no need for further meetings, what do we do? And I will tell the members. If there are no further meetings on the 6th of October, possibly the first House Committee will make a report. And then on the 18th, this will be dealt with. 18 is about whether to extend or not. If it's extended, then it will be the 7th of November. If not, and if no one on the 18th or before propose any amendments, then it will come into effect because it's negative vetting. I just want to confirm. after today's meeting, they will give us a written explanation about the merits and the disadvantage, because this affects a lot of things. So make everything clear. We can find some solace in this. The 3 weeks are agreed by the Bar Association and the Law Society. They've been consulted, but we are legislators. We have the responsibility to make sure everything is in order. So just give us a detailed explanation. Mr. Chow? Page 14, the change of the English version. I see some change on page 14 of the English version. It's a table. Well, since there is a change on page 13, so they will list out the entire section, because that's their practice. This is for the sake of completeness. Yes, they have wasted half a page. They've wasted a page. Well, meeting adjourned. Thank you.
我以為幾個字。